and welcome to this webinar to discuss the key takeaways from the recent judgment of the Competition Appeal Tribunal in Royal Mail and BT against DAF, which is the first UK case to deal with damages arising from the trucks cartel and only the second UK case dealing with damages from a cartel to reach judgment. It's a hugely interesting 300-page judgment which deals with much complexity. I'm Helen Davies, KC, a barrister at Brick Court Chambers, and I'm joined by Colley and Anca Cojoc, both antitrust economists at Cornerstone Research. And together we're going to focus on the tribunal's treatment of the economic evidence. But to summarise for those who haven't yet read the full 300 pages, Royal Mail and BT claimed they were overcharged by around 10% for the trucks they bought during the 14-year cartel and were unable to mitigate this loss. The defendant, DAF, adduced detailed economic evidence of no overcharge and also said that any overcharge would have been passed on or otherwise mitigated. And the tribunal ultimately awarded damages of 17.5 million pre-interest on the basis of a 5% overcharge with no discount for mitigation, so essentially just cut the overcharge estimates down the middle. The tribunal comprised a High Court judge, a business figure and a competition economist, and they made some quite stark observations on the economic evidence. We're going to try to unpack the tribunal's thinking on the key issues, starting with overcharge, pass on and then interest, and reflect on some takeaways for future cases. Now, Liam, before diving into the empirical analysis of overcharge, can we consider the debate on plausibility, as it set the scene really for the tribunal's assessment of the econometric evidence?
Yes, that's right. I think it's fair to say that there was more debate on plausibility than was expected, given it's a low bar. The claimant presented this as a no-brainer. The defendant, however, challenged whether it would be feasible to successfully coordinate on transaction prices, given the bulk of the exchange was on list prices. The tribunal pointed, first of all, to the factual witness evidence that there was a material link between transaction prices and list prices, and made a broader common sense point, common sense always being a difficult thing to trump with economic theory, that surely with a 14-year cartel, it was at least plausible that the defendants got something out of it. So ultimately, the tribunal thought the defendant expert's position on plausibility was simply implausible. And I think this did colour the subsequent review of the econometric analysis, because I think that that by mentioning the risk of confirmation bias, the tribunal was questioning whether, having erected a scaffold of scepticism, the defendant expert could then embark on the empirical analysis with a genuine open mind.
Well, let's turn to that evidence, because obviously one might conclude that simply there was a loose wielding of the broad axe to arrive at 5%. It was halfway between the position of the two parties, but it's fair to say there was a lot more to it than that, wasn't there?
Yes, I think that's right. I think the empirical analysis was dominated by the econometrics. The tribunal agreed that the causation question could be satisfied sufficiently with econometric models as long as they were well constructed. So there was a lot of probing, detailed probing of how well constructed they were, and that focused on three big swing factors: the treatment of exchange rates, the treatment of the financial crisis, and the higher costs of emission standards. I'll focus briefly on the first two, but for all three there was the old chestnut of the identification problem, the difficulty of disentangling the effect of the cartel when there are other factors moving around at the same time. So, for example, with exchange rates, the start of the cartel coincided with a sharp appreciation in the pound. Exchange rates were generally an important issue because trucks were built on the continent in euros and sold in the UK in pounds, and the experts adopted sharply contrasting approaches. One did everything in euros, one did everything in pounds. One used spot rates, the other used a prior year average. And this had a big impact. Switching from one approach to the other made the overcharge evaporate. The tribunal were dissatisfied with both approaches. They thought there was no single right answer. But they expressed their real dissatisfaction, I think, with how doggedly the experts stuck to their view that their approach was the only approach, it not being lost on the tribunal that their positions happen to neatly coincide with the positions of their respective clients. Similarly, on the financial crisis, again, a big issue, truck demand collapsed during this period. The claimant expert brought in additional controls to allow for this, and that raised various technical issues. But the real concern of the tribunal was that these controls were only brought in after the claimant expert had found a much lower overcharge of 1.5%. And this only came to light quite late in the day. So I think actually on these issues and a host of other issues, the tribunal really rolled its sleeves up and got to grips with the analysis to reach its own view. In doing so, I think it's fair to say that the tribunal was perhaps informed by the experts' analysis, but given the concerns on partiality, not greatly assisted by their opinions.
Indeed, I mean, as you say, one of the standouts just from the judgment is quite how unhappy the tribunal seems to have been with some of the intransigence on the part of the experts on some of these difficult issues, so much so that it ultimately led them to question the experts' independence. I do wonder also, though, whether there was a sort of air of resignation that this goes with the territory of economic evidence in these kind of cases. Do you agree with that, or do you think there's something that can be done?
I agree there was an air of resignation, but I don't think it necessarily goes with the territory. But I do think that actually more can be done to give the courts comfort around these issues. There's an old saying that econometric models are a bit like sausages. You wouldn't want to see them being made. But I think this has always been known about with scientific experiments of this sort. There are a wealth of measures that can be taken to at least reduce the scope for bias. Helen, on the last case we worked on together, I was asked to write explicitly to the court on such measures. Experts are inputting increasingly ahead of trial, often just to influence the disclosure exercise. But I don't see why there can't be more detailed methodology statements that cover off the likely modelling choices that are going to need to be made. This wouldn't solve everything, but I think it would give the court a bit more of an anchor, actually, on which to evaluate subsequent decisions.
I'm sure that's fair. And in fact, I'm increasingly seeing, in the context of these kind of cases, tribunals, Competition Appeal Tribunal, the court requiring exchange of methodology papers between experts, in fact, well in advance of disclosure, often in the context, as you said, of informing the disclosure exercise. But nonetheless, it does require the expert to sit down at that early stage and try and work out how they're going to construct their model and what are the issues that might be challenging them. I think it's fair to say also that those exchanges aren't reducing the scope of the debate in cases between experts. People are getting more entrenched potentially in their position. But it does mean that if you've got that early exchange, you don't have the problem that certainly appears to have happened in trucks of choices being made with knowledge of what the result might be. And it's certainly obviously not desirable from a tribunal's point of view to see that happening, because it does potentially give the impression of bias and should be avoided, therefore, I think. Now let's turn to Anca, who's been sitting waiting patiently to brief us on the second major limb here, pass on. That's an area where the law and economics overlap and some would say collide. So I'm fascinated to hear your perspective of what the tribunal has said.
Thank you, Helen. I think there is no better illustration of the collision point that you are referring to than the fact that the economist on the tribunal wrote a dissenting opinion with respect to pass on. The tribunal had to grapple with lots of issues on pass on, and I'll try to touch briefly on these ones. So first, there were three theories of mitigation that defendants put forward. The first two look to the extent to which the overcharge would need to be offset, given that the claimants may have either benefited from lower prices on additional equipment that they purchased, or from a slightly higher price when they resold the truck. Both of those two theories were actually dismissed on the grounds that the evidence provided was not sufficiently robust. Now, the biggest debate actually goes to the question of the supply pass-on, and this is where we can see defendants and claimants having totally opposing views as to how the regulatory process can facilitate the pass-on of the overcharge into retail prices. On one hand, we have the defendant who thinks that given that the two claimants have been regulated and their prices are set up through a regulatory process, then the pass-on is likely to be automatic. On the other hand, the claimants are actually arguing that the regulatory process is not sufficiently fine-tuned to capture a small change in their cost base, so the pass-on is very unlikely. When we are saying a small change, we are talking about, in terms of a proportion, like less than 1,000th of their overall cost base, which is pretty tiny if you were to think about it. Now, the majority of the tribunal actually agreed that indeed the truck costs were too small and too remote from the overcharge to have an impact on the retail prices, and also there were too many steps and too many regulatory judgments that were involved in setting up the retail price. Thus, the pass-on cannot be considered to be automatic. On the other hand, however, the economist on the tribunal actually disagreed, and in his view, it didn't matter how small the cost change is going to be. Given that we have the regulatory judgments, it's very likely that there would be a change in the prices, whether it's going to happen all the time or irrespective of how large it is as part relative to the overall revenue of the claimants.
Can we consider the precedent value here? I mean, as you've said, the tribunal, in applying the legal test to pass on, was influenced by both the tiny size of the overcharge in the claimant's cost base and the weakness in the links in the regulatory chain. But of course, that doesn't mean that in other circumstances there couldn't be pass on, and the opposite conclusion could easily be reached.
Yes, I agree. I think we can easily envision situations where where the size becomes less of an issue as long as the chain between the overcharge and the prices is still remains strong. The strongest link we can think of is when we are talking about pricing based on cost plus. Here, the pass-on is automatic. However, However, outside of this situation, pricing should reflect the fact that the least profitable customers are going to be competed for less aggressively. So if we were to think about an example where firms are pricing based on the expected value of their customer base, it's very likely that even a small overcharge that can lead to a change in value can translate into an increase in prices downstream. So I think from my perspective, the debate on the pass-on is likely to continue, and it's going to be very interesting to see how it's going to play out in the future.
Now, before we close, any observations on the tribunal's approach to interest? Because that's another area where the legal analysis and economist's perspective often collides.
Yes, the thinking on interest was, forgive the pun, interesting. The ultimate question was, what would the claimant have done with the extra cash had it not had to pay the overcharge? The tribunal came out with the conclusion that it most likely would have paid down short-term debt or carried out additional short-term investments, depending on whether it was in borrowing or saving mode. So a blended rate was used that incorporated the cost of debt. The tribunal rejected using the higher cost of equity on the basis it didn't think this was a hard cost to the business, like, say, an interest payment, but was merely a higher return sought by shareholders. I think that actually that same conclusion can be reached in a slightly different way, in the sense that a higher cost of equity can only be justified by the fact that there are additional or higher risks associated with equity investments. So to reward a claimant on the basis of the higher cost of equity, to use that to roll up the cash award from time of injury to time of trial, would be to compensate claimants for higher risks that they did not in fact face. And I think that line of thinking has been made more explicit on other cases such as Korean, and I think it's the right outcome in this case.
Well, thank you both very much. I hope the audience will have found that as interesting as I did. I'm sure we'll be debating this for many years to come.